We want to bring a quick update with regards to the USCIS announcement that it's approximately 760,000 or 780,000 applications will be received by USCIS. Emily, your prediction came very close. You said 750, 760. So somewhere around that figure is the one. What is shocking right now in this announcement, Emily?
Yeah, I think more than what's in the USCIS announcement, we have this article from the Wall Street Journal that points out that 96,000 people submitted multiple entries in the lottery, and that came out to a total of 408,000 people submitting, or 408,000 registrations. So 96,000 people are trying to game the system by filing with 4 to 5 companies each. And that led to 408,000 total registrations of these duplicates that we've been talking about.
Wait, Emily. So what you're telling is actually the total number of applications that the people that applied is probably less or more or less the same last year, but it's these 96,000 people that filed multiple times, and then they are the ones that have done 408,000 of those people?
Yep, that's exactly right.
And where did you get that figure?
So that is from the Wall Street Journal article that was published this morning. That figure is not anywhere in the USCIS public engagement announcement, which they emailed out at about 10:30 this morning Central Time.
So Emily, when I looked into the USCIS announcement right now, I'm looking at in 2021, they already identified people who filed multiple registrations, which they said is 28,000. Then it became 90,000 in 2022 fiscal year. And in fiscal year 2023, it's 165,000. And this year, fiscal year, that is 2024, 408,000 out of the 780,000. That's a lot of number, Emily. So what do you think so the USCIS will do right now with these people? You know, we have questions like nice people like Shobha is asking on the YouTube, oh my God, what's happening? Genuine H-1B guys who wants to apply are getting affected. So what is USCIS done previously, what it's going to do right now, what it's going to do in the future?
Yeah, what we can tell from the figures that they shared, they did not kick these people out lottery and conduct the lottery just on the legitimate registrations. They kept them in and selected 110,000 of the total 750,000. So that means probably more than half of the ones that were actually selected are from these multiple filers. So unfortunately what that means is, and what they've done in the past, they will select people that did this. They then let them submit their petition. They approve the petition even. And then a year later, they go back and revoke it, which does nothing for the people that did not get selected because their chance is gone. That number doesn't get put back into the pool when they revoke it so much later. So right now we're seeing revocations happening from last year's lottery. So it's too late to really help anyone. And that's technically really been how they've been doing this for years. They've gotten a little bit faster. It used to be 3 or 4 years after the lottery when they would catch these people and revoke the H-1B. Now they're doing it within a year. Still doesn't help the however many 350,000 that may not have gotten a good chance.
So what you're telling is practically out of the 110,000 applications that they selected, 60,000 plus applications are fraudulent people, and yet they will be allowed to file the H-1Bs, yet they will be allowed to get the H-1B approval. The genuine people who are waiting in line will not get in because of these stupid fellows are going to get in. Of course, they're going to get shot at a later date. That's a different issue though. But that's not gaining for the people who have been waiting for the H-1B. Why can't USCIS discard this 408,000 applications and only select the process from 350,000 though? Now, it doesn't mean that these 350,000 are genuine. There may still be some fraudulent thing there. But at least they should eliminate this 408,000. Can they not do it?
I think they can do it. Right now, made it very clear that they allow one person to register with multiple companies, and their way of stopping companies from colluding together is an attestation that they have to click on before they hit submit. The company has to hit that, confirming that they didn't collude with another company to unfairly game the system. That attestation is new this year. It wasn't there before. A lot of good it did, but I'm assuming they're going to use that as part of the criminal, enforcement that they're going to bring against
what
these
good
people.
that attestation did, Emily?
Right.
It increased the fraud by almost 3 times.
Yeah. Yeah, because they just keep allowing this to happen. And we've been talking about for years that there is fraud, that people are doing these duplicates. They do eventually get revoked, and we tell people don't do it. Don't get into that trap. And this is why, but obviously people are not listening to our advice on that and going and doing it anyways. And it's hurting the legitimate applicants.
So for the people who have applied in the fraud, though, they are listed right now who are fraud. They're telling that it's 408,000, though. We strongly recommend that you contact an immigration lawyer. For those people who are not selected in the lottery, what can they do? I would suggest them find out these companies who did it, report them to USCIS. There is a fraud report of the USCIS. It's there on our website called rnlawgroup.com. Report them. When you do report them, give the specific details. If you know the employee name, give the employee name too. Because if they have unfairly gained advantage by manipulating a system, not only manipulating, by committing fraud, you should report to them. Emily, I've seen some drastic enforcement in the past 6 months on these duplicate filings as compared to what it was before, Emily. Before, they were just going after the companies just a little bit, though, and they were prosecuting the companies to some extent. But now I've noticed that when these people go for stamping, though, they are hitting them with a misrepresentation because this employee has cooperated with this employer in fraudulently filing the H-1B. What they are telling is that you are permanently barred to ever come into the United States. That is the first time I saw, only in the past 4 or 5 months, though. I never saw that before. When employers have committed some fraud, we have never seen employees getting the misrepresentation. They started, I think so, which is good according to me, because these people should not have cooperated, though. Anything else, Emily, to keep on adding on these things that you have more knowledge about?
Yeah, I think, just kind of looking into these numbers a little bit more. So we had 758,000 eligible registrations. So there were actually 781,000 about that were submitted, but there were actual duplicate registrations where one company submitted the same name twice. Those were kicked out of the system, as well as cases where they submitted the registration, but for some reason the payment didn't go through. They were kicked out of the system and not included in the lottery. So the number that were actually included in the lottery was about 760,000. And when they selected 110,000, that's about a 15% selection rate, which is exactly what our office was seeing based on our own numbers and what we were hearing reported from other attorneys. So now we know they're selected 15%. That means they already said there's 408,000 of the total are multiple registrations. So 15% of those means 60,000 of the ones that are selected, more than half of the ones that are selected are multiple registrations fraudulent. And so again, these people are getting lured into, now they got selected, they're going to go ahead and file. And I think now that they're filing, when USCIS wants them to file, that's why they're selecting them. It's to gather more evidence against them so that they can go back and revoke later and possibly go after them criminally, which is good to see them doing that. The problem is it messes up the whole lottery for everyone else. We might, because again, of this 110,000, if 60,000 are fake, 50,000 are possibly mostly legitimate. There's 85,000 slots. We could see another round of the lottery this year because of all this fraud. So we won't know until July if that's going to happen, because they have to wait until the June 30th deadline to let everyone who was selected get in this time around. But I do have higher hopes now that there will be a second lottery this year because of just all of this fraudulent activity.
I have the question from Raj Madhisetti is asking, why do you guys call fraud? Why not? It's a loophole. Now, loophole is different than fraud. This is really fraud. Now, what is the loophole is, if an Apple computer wants to hire an individual and they have a real job with Apple, and this particular individual also gets a job offer from a company called Microsoft, and it's a real job offer, and they really have a job. And if Apple files a H-1B and Microsoft files a H-1B, it is a loophole. That is a loophole. Now, if a consulting company doesn't have any job at all, and they go on a truck, Emily, they really go on an SUV, go to each village and find some people to apply for the lottery. They don't check their resumes. They don't have any end client. They don't have any job. They file the lottery. Only after they select in the lottery, then they go after and find to see if there is a job where the employee can provide the job for them. Here, the employer is not providing the job. Employee is bringing the job. Now, at the time when they're filing the H-1B, these people are not working for those companies. They're just filing. They're not working with any end clients. They're just filing without a job. That's the reason, Raj, it is not a loophole. It's a fraud. When you file the H-1B with the job where the person has a real job, then it is considered as a loophole, definitely. But if there is no job, the employer is attesting, saying that I have a job opportunity for this particular employee. When there is none, that is considered to be a perjury. It's a crime. It's a felony, punishable by a lot of years in jail. Now, if the person signs more petitions, each petition may end up in a jail up to 5 years. So if they file about 20 applications, so that is up to 100 years. That's my calculation. So yes, that is fraud. It is not a loophole. Please understand that. Yeah. Question from Darim Pitwa. Why let the crime happen and then catch? Why not stop the crime before? Good question. We were suggesting to the USCIS before that instead of having, what is it, $20 or $10 right now for the lottery system, what we're telling is that take all the money of the filing fees of every application. Let's say, for example, what's the filing fees, Emily, for a typical H-1B?
$2,400.
$2,000. Yeah, depends on the company size. So if the company is filing 100 applications, they should take the money of all of those 200 applications, though, and then only give them back on the ones which are not selected in the lottery. That would have eliminated at least 90% of the fraud which has been committed. But here, they don't have a job. You're right, absolutely. They should have, Dharamil, they should have not let it happen, because the victims here are the people who did not get selected in the lottery. The victims are the people out of the 350,000 applications, Emily, only 50,000, the genuine applicants. Now, we don't know how many of them, but at least a good number of them are genuine applications. At least they are identifying as single time filing applications. Out of those 350,000 applications, only 50,000 got selected. Rest of the 300,000 people are the victims of this crime. This fraud activity by the employers and the employees who has colluded in it. I think so. Some of those people, will see them in the jail pretty soon. We hope so. They will be in jail. Now, for the employees, though, we strongly recommend that you contact a lawyer who have been helping these employers to commit the crime. Now, typically when the investigation happens, though, the USCIS, ICE, will contact the employees, will speak with them. Hey, buddy, where were you at that time when you were working for the job? And they will contact the employers. Of course, employers will go immediately to the criminal lawyers, and they will say they will not speak any word, because that's what criminal lawyers will tell. Don't speak any word to the ICE people. Then they will investigate it. So it's going to be a lot of action that's going to go on. A lot of criminal criminal lawyers will get a lot of business. At the same time, a lot of these people will be punished. Now, there are some people that may run away. There may be some people some escape, but most of the people will be punished.
Yeah, and you know, we've talked before about the fee increase that's supposed to be coming soon for all the different case types. That rule is in progress. Commenting was already done. And one of the fee increases proposed was raising that $10 registration fee to $215. And part of the reason for doing that was to cut down on these multiple registrations and this fraud. But I don't think $215 is going to stop anyone. So I don't think that's the way to do it. I think that they should be looking at this point, clearly what they're doing is not working. They just need to completely eliminate the option of filing for one person filing multiple different companies. Just one person gets one slot. If you have 6 offers from FANG companies, you decide which one you're going to set forth and you file with that one. And if you're selected, great. You can change employers in October. There's no need for you to file with multiple employers. And if you're really getting 6 offers from FANG companies, you're probably O1 material. Why do you even need to be in the H-1B lottery for most of these people? So I think that they need to come up with a drastic change. Some people have been talking about, letting it be employee-based instead. The employees get to submit their own registration, and only those that get selected can then go to an employer and say, hey, I've been selected, will you sponsor me? And they get to choose the employer that way. I don't think that's the right way to do it, because at that point now you're opening up to employees. How are you going to know that these employees are qualified? Who's going to verify that they actually have a bachelor's degree? Or a degree that's related to the field, which is required for the specialty occupation for an H-1B. So I think number one, they need to take the money, all the filing fees as soon as they're selected. And if that's not going to happen, then they need to just limit it and say you can only have one name, one company, that's it.
A question that's coming in from Ashok Pratap is, will they conduct a second round of lottery? Yeah, when we look into the selection though, last year they selected 127,000 and the before years 131,000 and the before 124,000. 110,000 seems to be low for us. There is a good chance that because there will be some denials, there'll be some, the persons who file duplicate filings might have get selected multiple times too. So they definitely was a room, but I think so even if they would conduct a second lottery though, your chances of getting selected seems to be less than 3% to 5%. Somewhere about 3 to 5% is your chance of getting selected, because there are about 750,000. Out of them, 110 are gone. So now you are left with approximately around 650,000. Now, even if there is a room for about 10, 15,000 or so, it's very less probabilities. There's very less probabilities for the people to get in, unless they eliminate this 408,000. This is a question that's coming from, I don't want to name the person, Emily. There are a lot of people, what they say is that my lottery is picked up with this fraudulent company, and after it's been selected, filed in the H-1B, I'm going to move to my end client. That's definitely a classic fraud. We know there is no job for you there with that consulting company that filed. Now, I wouldn't say that all consulting companies are fraudulent companies, but there are some consulting companies that are fraudulent consulting companies.
Yeah, and just because you've moved on to a different company doesn't make it go away. They still go back and revoke the first H-1B, and then when they do revoke that first H-1B due to fraud, they come back and say, now you're not actually considered counted in the cap. So when your real employer goes to file their extension or they file an amendment, they're going to get a notice of intent to deny saying that, hey, you can't extend this person's H-1B. They've never been counted in the cap. So it does not go away. It will follow you with any subsequent filing that you do. And we see that more and more.
A lot of people ask this question supporting these consulting companies. I can see them. Yeah, it's up to you guys. How do you look into it? When the ICE investigates it, they're going to look into there is a genuine job opportunity or not at the time of filing of the lottery, though, not at a later date. They must have the job opportunities at the time of filing, though. If later they acquire, that doesn't count. It still counts as a fraud, Emily, you said one thing, but I want you to clarify the things. So let's say I got selected with a fraudulent company A, and we know the USCIS is going to still approve these stupid H-1Bs, and then I move to a genuine company called Apple, and you're telling that they will find at that point of time and then revoke it. But no, for some people, they did not. From Apple, let's say, for example, I'm going to go to Coca-Cola company. Can they still revoke the first H-1B and then I will be out of H-1B? Is that what you said?
Yeah, absolutely. So even if you've switched
But my
companies
H-1B
10
with
times,
Apple is good. My H-1B with Coca-Cola is good.
right, but because that very first one was fraudulent, they act as if you were never actually counted in the lottery. They take your cap number away. So that means Apple is now subject to the cap. They have to go through the lottery, or Coca-Cola now to sponsor you has to go through the lottery. So because they didn't, they will then revoke those H-1Bs, and you're stuck with no H-1B and have to go through the lottery again. And likely leave the country, apply for a new visa to come back, and then get stuck with a 221G or finding a fraud at the consulate.
Anything else, Emily, to discuss?
I think we pretty much covered it. So unfortunately, not kind of what we were expecting based on our numbers. I had predicted about 750,000 when we first got our selection notices at the end of March. But this does confirm what we were suspecting all along. Doesn't solve anything for everyone. Hopefully they'll come up with a different plan for next year, and hopefully they will run a second lottery for those legitimate applicants that weren't selected this time around.
I mean, do you have any defense? But recently we're receiving a notice of intent to revoke. Do you have any defense for these employees?
For the employees, so if the situation is truly the employee had no idea that this was happening, and maybe the company just worked with other companies without the employee's knowledge and the employee did not pay anything, the argument would be that the employer is the one that did the fraud, and you're basically punishing the innocent employee by taking away the employee's cap number. That does nothing to hurt the employer who did this. And the way that the regulation is written, it talks about when the employee conducts the fraud, that's when the employee's cap number should be taken away. It doesn't specify that when it's the employer only that does the fraud, that the cap number should be taken away in that situation. So those are kind of the arguments that we make. A lot of these cases have to go to court after the revocation actually happens. And we've seen some of them have been reopened and reaffirmed. At least the revocation still stands, but without the fraud finding against the employee, so that they can keep their cap number going forward.
What kind of notice of intent to revoke have you recently seen, Emily, for the multiple filings?
I mean, so these are cases where they were selected, they filed the petition, got the petition approved, and the company did this for multiple people. So in the notice of intent to revoke, they actually have the names of all of the companies that submitted the same group of people. So they might have 10 beneficiaries and 5 different companies submitted those same 10 names. So they can see, I mean, this is all done online. They can data mine and figure out which companies have the same list of names. On top of that, they go and look at the FedEx that's used to file the petition. These companies are using the same FedEx account. And then they share an office, or they have the same person signing the checks. So they do a lot of that digging and trying to figure out how to tie these companies together. A lot of times they have a relative of one company and a wife of another and a cousin of this other company. They all are related somehow, or they are able to piece it all together, and they spell all of that out in the notice of intent to revoke. So there really is no way to argue that they did not collude together. It's very clear.
They do also record the IP address and a lot of other things that our own programmers write those things. So yeah, they do have all different methods. The only problem is, Emily, that they don't do it immediately. That's the main problem. I mean, it's affecting the genuine people. That's where the problem is coming, especially, people like Dharmil Pitwa. I mean, these are the people who are getting suffered because they get punished later on, but our guys are not getting the application accepted. That's a problem. So USCIS should have acted it much before rather than acting it afterwards. Anything else, Emily?
One good question that came up is how can USCIS differentiate between a fraud consulting company and a genuine consulting company? Again, they do look at companies banding together to file for the same group of people. So a genuine company is not going to be doing that. They're only submitting for their people. They're not going to their friend's company and asking them to submit the same list of 10 names. At the same time, a genuine company is only submitting a registration for someone that works for them. And most of the time, these people are already in the US, they're on F1, OPT, they're working for them. So that is pretty clear that that is a genuine consulting company compared to fraudulent one where they just say, hey, I don't even need your resume, just give me your passport and I will submit your registration. And then they share that passport to 10 other companies that also submit the registration and we guarantee you get selected. Those are red flags for sure.
Anything else, Emily?
I think that about does it.
Thank you guys for tuning in. If you have any questions, you can always contact us. You can make a consultation with me, Emily, or any of our good lawyers at rnlawgroup.com. Keep tuning in. Our weekly Tuesday, 5 to 6 p.m. updates.